We're going to do a quick hit here right at the top on this update to the Fair Labor Standards Act. Can you give us a bit of a run through on the salient changes that contractors need to be aware of?
Yeah. FLSA effective March 11th. The gray area that many contractors had, my background, obviously with the name roof strategist, I'm in roofing, but no matter what it is, what industry you're in, the rule between what is considered an employee versus an independent contractor has been a gray area that many contractors have walked. However, they've taken that gray area and they made it black and white. And there's a new economic reality test, which is a 6-factor test looking at the employee-employer relationship, which in a nutshell means there's pretty much no chance that you will win an employee misclassification investigation, with penalties including back taxes, financial penalties, by the way, is both on a state and federal level in the U.S., as well as fines. So you can be, and that can go, my understanding, and fact check this because I'm not a lawyer, is back to 7 years. And there's a lot of folks that say, hey, well, we're going to do 3508 direct seller. My team invoices me and they have their own insurance. That's all cute. And that's all what we used to think. But quick and dirty, I just talked to an attorney who's one of the top 50 construction lawyers in the US, who's been practicing for 3 decades, and he has never once seen a winning case of someone investigated for employee misclassification who had independent contractors that won. And that was before the law went into effect. He shared with me how this is cracking down even tighter within the next, which was within the first 30 days of the law going into effect. So in a nutshell, there is virtually no way around it. You got to make your team employees, your salespeople. The implications on crews is very different. I'm not the right one to talk to about that, but the law does impact some of those crew relationships. You have to be very mindful of your relationship. When I say crews, meaning your installers. And yeah, if you jump on my YouTube channel, if you search Adam Bensman or the Roof Strategist, you'll see I've done videos on FLSA. I did an announcement video. I did a deep dive into the 6 factors, and the video tomorrow. So May 2nd will be airing with the attorney.
Tell you what, guys, we're going to link that somewhere here. We'll have to do this in post. We will link to that full interview because I think that that's absolutely worthwhile. In layman's terms, though, and we don't need to spend forever on this, but in layman's terms, that gray area was basically this thing, and it always struck me as odd as Canadian, like working with Americans, and it's very common it's not just roofing, by the way. You see this a lot in landscaping, you see it a lot in painting, and I'm sure a few other industries as well. But basically, it's one of these exploited gray areas where the contractor goes, my crews, and they refer to them as my crews, and they often wear their clothing. And in many cases, they do 95% or 100% of their business. The crew's quote unquote business is done. Like their one client is your roofing business. Yeah. So basically in every way, shape, and form, these people are employees, but because it's more tax efficient and it's lower risk and it's kind of more convenient, they set it up in such a way that their subs are technically subcontractors, not employees. And you're saying that that's all coming to an end now?
Virtually entirely coming to an end. And again, for the installers or subcontractors that are doing your work is different than salespeople. So in the roofing space, for example, a large percentage of the sales force in the roofing world and in the construction world is 1099. And again, a lot of people, well, they pay for their CRM. Doesn't matter. They have their own LLC. They invoice me for this. They can set their own hours. I don't tell them where to be. So if you go on the Department of Labor's website, if you just Google economic reality test, there's 6 factors. And basically what they've done is all of those little loopholes, they've shut down down to how that person is managed. And they've included language in there, including via technology or digitally. So meaning if you have a CRM that they're using, they're being managed. If they don't have the ability to profit and loss. And I know, by the way, in that longer video, I so many contractors, like the amount of horrible advice going in these Facebook groups, the industry Facebook groups, well, they can set their own hours and they pay for their own marketing. All the language, yeah, they can pay for their own marketing, but does it benefit the individual or the company? So if the sales rep is marketing for leads, but they're only selling for the company, and the marketing says, work with me with XYZ roofing company, then that law, the interpretation of the economic reality test says, well, that investment in their own marketing is for the benefit of the company, not the individual. So the supervision regulation, whether or not they're making investments, whether or not they're requiring training, meaning like if you have to train them on your own operations, if you're training them in your CRM. So there's pretty much every single angle. If there's an investigation looking into you, I don't see any possible chance that you're going to win. I have talked to 3 separate attorneys on this in depth, and not one has said there's a shot. I've heard of some attorneys saying that you have a chance, but when I look at a gentleman who's a top 50 lawyer and who's done this for 3 decades and has never once seen a winning case when it actually goes to trial, like it already was gray, and now those gray areas are like, there's no chance. So long and short of it, if you want to be fully compliant and not be worried about a lawsuit triggering an employee misclassification, an injury triggering a employee misclassification, someone filing for unemployment and not getting it, and then looking at employee misclassification, and if they weren't paid minimum wage or overtime, because that's another consideration now within here, or if there's an investigation due to insurance, which has happened. People have auditable policies, and then they say, hey, man, your entire sales force should have been on payroll. That's employee misclassification. And I had a contractor that owed 6 figures in insurance because they had an auditable, I believe it was 6 figures. Don't quote me on that. All I know it was a boatload of money that the carrier came to. So there's a million and one things that could open up an investigation.
Yeah.
And I'm going to end on this note because this will scare the heck out of people. There's literally, if you search the IRS website, it's called the Whistleblower's Office. So a disgruntled employee or disgruntled competitor, you can go to the IRS website and complain about someone and report them for employee misclassification. And should their investigation unfold, and then there are back taxes collected, the person who blew the whistle on them is rewarded 15 to 30% of the revenue collected.
Oh my God.
So I just wanted to end on that note. Like,
you
guys can try to skirt it, but like this very well could come back to bite you hard.
So it sounds to me like what you're saying is like, hey, big policy change. And by the way, I'm also hearing people sort of like basically trying to game the news system. Well, I have this document that I give to my subs and I'm really explicit about what not's included. So like I should be good. And it's if I'm reading between the lines on what you're saying, it's like that's and also guys, please go watch the full interview. But like it's probably like stop trying to like game the system. You probably just need to get on the right side of this one.
For your sales force, because that's one of the loopholes in the law, on the fact sheet is let me pull it up so I can cite it. Whether the work performed is integral to the employer's business. So if you're a painting company and your painters are independent contractors, I'm just going to ask you, is painting an integral part of your business?
Yes, it is your business.
Okay. So that's a problem. Now there are nuances on using crews, like roofing is if you're classified as a general contractor who does roofing, again, I'm not an attorney because this part of the law is very complex versus the type of ownership for the entity, the type of control of the entity, whether or not that crew is doing work for other subs as well, to the other companies, as well as a sub for other companies. So with your manual labor, it becomes a little bit more complex from a sales standpoint, like hopes and dreams, buddy. They should be employees and you can sleep at night.
Listen, if you like that clip, you can watch the full episode by clicking here. If you're not yet subscribed, you probably should be, and you can do that by clicking right here.